Hello. The second thing I'm looking at today is the Patent Act of 1952. So, in my previous video, I talked about this Supreme Court case from 1850 and how it was that Supreme Court case that kind of set the precedence for what obviousness is. However, one thing that struck me about that was that typically you would expect the congressional branch to be passing specific laws as to what the rules and norms should be. So it was 100 years later, in 1952, that actually specific language was enacted by Congress to determine what obviousness was. And the reason why they felt the need to pass this bill, well, there were several reasons, but largely there were a lot more patent disputes being held up in court, and they needed to being sent to court, and they needed to provide clarity in the law so that there would be less disputes arising over its interpretation. So specifically, Section 103 mentions that the subject matter as a whole would not have been obvious at the time the invention was made to the person having ordinary skill in the art to which said subject matter pertains. So that is the specific language that patent officers, and then as well as people in court, lawyers and judges and jurors, will need to answer to and determine when there is a dispute about the obviousness of a particular patent invention. Thanks for listening.